Yes. Yeah. Okay, so then after I could just turn the mic back. Okay.
Okay, everybody. Can you hear me okay? Yeah. Okay. There we go. So, if we can settle down, we'll do a half, last 20 minutes, 25 minutes of really the entire reason I brought you all here. So whenever an academic decides to organize a conference and they don't write a paper themselves, you know that they're there to pick everybody else's brains. And so that's what we're about to do. Bob's not here, but we had a fascinating debate yesterday about the relevance of much of legal academic research for the bench and the bar. And we have a slight disagreement more on viewpoint than I think on substance, right? And Bob, correct me if I misrepresent your argument, which is much of legal academic research is bunk and irrelevant to the bench and the bar. About right? Okay. But not today, right? We, right? Yeah. Mod, mod, right? But one of the things that was an impetus for this conference, right, was discussions that I had been having with the WIPO division on uh, genetic resources, traditional knowledge, and traditional cultural expressions, that one of the key problems for the generation of norms, the generation of law on the protection of traditional knowledge, was the lack of really strong academic foundations and rationales for it that were, that were translatable into the policy framework that the negotiators were using. And the thing that Ben pointed to was they had done a lot of work with many countries, sort of persuading them to generate TK laws. So you saw it, as has been pointed out, the Stockholm Protocol in Africa. You saw the OAU, the AU, African Union sort of policies. But to some extent, they reflect the generic problem that a lot of this is externally generated. They went to the countries and talked to them and said, you might need this, but you didn't really have a sort of organic internal IP office, ministry, plus interest groups domestically that really organically generated that, right? It's part of their strategy to essentially proliferate the kind of legal protection such that you'd have a critical mass of national governments that had such protection that could then come back to the international level with a quasi-harmonized system already that would allow for an agreement to occur. Right? But that hasn't been persuadable for countries like Australia, for the US, for Canada, even for much of Europe, right? That process has not been, been the case because those countries have, for better or worse, much stronger domestic institutional mechanisms for generating law within the domestic frameworks, right? And so when I moved from Europe here to working in the US, one of the key areas I wanted to work on was to think a little bit about in these economies, in these markets, in these countries, how do we generate academically and then translating that into the policy framework a basis and a foundation for the protection of indigenous knowledge that can translate to the IP Academy, but also to the Native Indigenous Law Academy, where historically there has not been significant working together and overlap. So, to throw this open to the floor then, what should the Legal Academy do? What kind of research agenda should we have if we seek to succeed in providing and generating domestic constituencies, domestic interest in a successful, and again, I don't want to prejudge what entails what we mean by successful, but that provides a means for equitable, right, exchange of information between the native indigenous groups and the municipal and members of the municipal state in ways that encourage both innovation and preservation and both the sharing of culture and the respect for the culture that the peoples have. What are the steps that we need to think about as a legal academy to address that, based on the work that you yourselves have been doing? So, who's got something for me?
I have the mic.
So, I come back to you as our keynote to sort of.
Thanks a lot. It seems to me that to answer that question, if you want practical results, you have to ask what moves the people who are going to be the decision makers in the area, and then who are the relevant decision makers. So if your model is to try to fix domestic law, you're going to have to figure out what moves the politicians who populate Congress and legislatures to change it, and generally that's not abstract academic research. It's very concrete stories of the losses and misappropriation. It's, to the extent it can be quantified, it's quantified numbers on those kinds of questions. It's the stuff you put in policy papers to fully address those kinds of questions. If, on the other hand, your solution isn't focused as much on domestic settler states, but focused, as some proposals that we heard today suggest, is on tribal councils and tribal forums to try to fix that and then use their lobbyists to get recognition for their laws, then the reality is that they need assistance from lawyers as well as from others in trying to craft and draft those specialized laws. And that's a very different kind of scholarly endeavor. It's a very practical scholarly endeavor than trying to make the case in the way we've made it today for settler states to recognize traditional knowledge. So it sort of depends on what your strategy is, because different strategies will produce a different focus, I think.
Okay. So that raises exactly this issue that I've been wondering about and that I've been working with, which is our empirical base, right, for talking about when and how much misappropriation takes place, right? The ways in which we can talk about that take place. In terms of your own awareness, how strong is that empirical base? Do we have that material now, or is it something that we would need to generate, say, in Australia or here in the US or actually in Canada? Do we have that empirical base of understanding what it is that's being misappropriated, how it is being misappropriated, and by whom, and from whom? So, in the context of Australia, Kathy?
So in Australia, we've got, I mean, there's been various attempts in terms of copyright to try and do that. A lot of it did drop out after the litigation, but in terms of patents and genetic resources, that's much trickier. There's endless inquiries into it run by IP Australia, who actually has a vested interest in a particular outcome anyway. And there's also a lot of fatigue in participating in those types of state-run enterprises. But I also would have thought from the perspective of Indigenous people, I know they said, well, it doesn't really matter how much it is at large, it just matters. And I think in terms of, and it's also, one of the things that we've skirted around, I think, in this discussion is the question of the problems being internal domestically, but multinational corporations are everywhere. And so for example, in terms of access and benefit sharing, you know, so there's been significant work done in Australia around a particular example where there was local access and benefit sharing agreements. They worked domestically, but the American pharmaceutical company just came in over the top and registered US patents and registered patents everywhere else, which just disenfranchised everybody and kind of sort of underlined the question about the importance of all the advocacy about getting things like that type of legislation in place domestically anyway. I guess I have a problem about quantification as being particularly helpful. On the other hand, select examples and case studies and stuff. I know it's been done before. There's lots of that type of material already out there. But I think it's important to refresh and regenerate these dialogues, because I would argue that regardless of what actually happens in terms of positive law or international treaty activity, the cultural activity that continues to push the legitimacy and to try and keep raising the currency of the dialogue. I'd go back to my example about the British Museum. It's only because of the activity through academia around that has led to the change in institutional practice. And even though it hasn't necessarily automatically led to the outcome that we hope for, it's definitely moved things along and created discomfort. And maybe that's, at this stage, in some places, that's making conservative institutions uncomfortable is in fact the best we can do, and I don't have a problem with that.
Judy.
Thank you so much. Most of us are legal scholars, and one point that needs to be made is interdisciplinarity is a very compelling approach to be able to tease out some of the issues you have raised. And most of us come from disciplines that are really very narrow, case-based, focused on problems and looking at laws in the books and so on. Like Fumi was saying, and Fumi's background is really very rich. She's not even from law to begin with, but she's traversed a lot of disciplines. So in terms of strategy to respond to this, there are many, many, many cases to be made. But do we have the legal tools as lawyers only to optimize those narratives and make them compelling? My suggestion is that we do not. And there is a need to reach out to economists, to reach out to so many people that can speak the language of policy that is so compelling. Lawyers are not people they are really people that scare policymakers. And so we need to find a strategy to reach out. And next point, which is so important, that this very conference has really made an issue which is commendable. Climate change. Climate change is an area, I'm not sure what happened last Tuesday, but the truth of the matter is that climate change is an area that we don't need to really sweat to make the point about traditional knowledge and the consequences for the global economy or for specific economies of nation states and the dangers of climate change. When you pull the string of climate change, you see food security, you see political crisis, you see so many dangerous things in terms of national security. That very string pulls it together. And then you see Aboriginal knowledge or traditional knowledge being really the stone rejected by builders becoming a cornerstone. And there is a lot of science to back this up. So maybe we should be thinking about strategy. And one of the things that I would suggest is that we should think hugely outside of our disciplines. We should be able to be very good in collaborative research. And because we do not have the language to really engage politicians and policymakers as lawyers, we could do better by reaching out.
So that suggests to me that we need to be talking more with the anthropologists and the ethnographers, right? The people who can tell us the on-the-ground stories of how people are dealing with and managing and generating and exchanging their knowledge, and give us and focus down on those places where we can clearly talk about, as you say, an injustice and unfairness, a threat to a common threat to the people involved. So I'm going to put a pin in that because I was about to use the term narrative, which we had a discussion with about yesterday, right? But I suspect one of the things we're going to have to be thinking about is the idea of narratives. The other thing that you raised was this idea of help with at the level of the tribes with the development of the law. And so one of the things that arises is there any utility in the idea of model codes, model laws, right? This is how WIPO has generated, right, these legal sort of adoptions by a lot of African countries, some Latin American countries, of protection of TK and TCEs and genetic resources. Is that something that could work in the context of Australia, of Canada, of the US, based on the domestic municipal law of model codes for the tribes? Is that something that would be workable? And actually, Preston might as well say a little something about this because we've been talking about this for a little bit.
Yeah, it is kind of a radical idea that maybe you should ask the traditional knowledge holders what they want.
Yeah.
And that's where you start. In the 16 years that the United States has been at WIPO, they have never consulted the tribes. They almost never include tribal expertise on their delegation, and they don't consult with the tribal lawyers within the United States government. And they don't want to, and they don't think they have to. We've heard of stovepiping. My analogy of the USPTO is you have stovepiping in Washington, D.C., USPTO is stovepiping on an island out in the Pacific. Okay, it has its own internal resources, it's a legal organization, so you don't have a lot of people who aren't lawyers within the USPTO, so they don't think they have any need. And also the way that the US government treats them is, that's so technical, we can't deal with that. It's up to them to deal with those issues. So, certainly participation in asking the tribes, and I think this helping the tribes out, certainly model codes. I was able to get the affiliated tribes of the Northwest Indians, AT&I, and the National Congress of the American Indian to pass resolutions on WIPO this year. They're just about 3 weeks ago, very freshly minted off the press. We had some help for the NCAI to kind of spiff up my language, which is not that great, with the Native American Rights Fund. So now we've got some lawyers involved, and they're moving, and the request is consultation and consent. So we have a demand now from over 400 tribes for consultation and consent, and we need to start hammering the USPTO to live up to, you know, the executive order and the memorandum on tribal consultation. And further, we want to go further than that. We believe consent is an important part. On model codes, of course, we need to do them. As I said, it's very difficult. It can be glacially slow because these are very sensitive issues. We now have a potential impediment that we can get around, but normally you send these things to the Secretary of Interior for approval, and they look at these things, and you know, they look for things like, do you have due process and so on. Usually approval can come. We may have to be sending them to Sarah Palin. I'm not sure that's going to be a fruitful ground for doing this. On the other hand, it may be time for the tribes to just start passing these and don't care whether the U.S. accepts them or not at this point. Just pass them and assert the sovereignty and occupy the jurisdiction. And then we can work from there. I think model codes are very useful. They will need a lot of, you know, localization, because different tribes have different agendas, different ways of viewing their knowledge systems, and you know, they may have different protections that they want. But that's the way I would start approaching it.
And so I'll raise one question that relates to that and ask both Kathy and Chidi and others to comment on this. When it comes to consultation, when it comes to information from Indigenous peoples and Indigenous groups on this particular issue of the protection of TK, do we have survey data? Do we have consultative data? Do we have narratives and case studies on this issue that can be the basis for our work? Or is this something that we will need to generate? Chidi, and then Bob?
I'll speak to my experience working around ABS,
Yeah.
access and benefit sharing in Canada. And the point is that the whole issue of legitimacy of representation by colonial states, which is always excluding Aboriginal peoples. And example is when delegates from Canada speak about access and benefit sharing, what you get from it as a subtext, not that they have said it directly, is that they are more interested in trying to support or facilitate a good business environment for biotechnology companies. And in other words, they frame themselves as countries that use genetic resources, countries that have zero traditional knowledge. But that flies completely far away from the truth. And because of that attempt not to legitimize or recognize that there is traditional knowledge, there are genetic resources found on Aboriginal lands across the country. But the country frames itself as, oh no, any attempt at benefit sharing, all this mumbo jumbo about traditional knowledge is just against investment. That is the mindset. And therefore, there is no consultation, and any attempt at consultation does not meet the minimum standard of what is required by law about consultation. So in a project that we do called abscanada.org, what we sought to do was to fill in that gap. Canada has not ratified the Nagoya Protocol. Canada has a new government in town. The honeymoon is still there. There is a very proactive attempt to reach out to Aboriginal communities and peoples in Canada. And then we said this is an opportunity to really strike the iron while it is hot. And what we did as a group of researchers is to begin to have a research project by and with Aboriginal communities on ABS. So the language of by and with is the ethical language prescribed by our funder, that you don't just go, like Preston was saying, you need to really have a participatory conversation and allow them to drive it and continue to create awareness on grassroots basis so that when Canada has to really confront the elephant in the room, which is the Nagoya Protocol, the most critical people engaged must have been fully aware. And I want to pick on what I had before. You don't need to sign on to the Nagoya Protocol before Aboriginal peoples and communities begin to develop their own protocols as to who comes into their territory and who uses their own genetic resources. That is their right to do. And in fact, our suggestion based on the evolving research is that you had better begin to do it now so that when they purport to consult with you, you are equally prepared and they will really do consultation properly so called.
I had wanted to comment on the model code question, but my answer dovetails very nicely with where we ended. Whether or not model codes make sense for tribes sort of depends on what code you're talking about. Yeah. If you're talking about a code of the type we just discussed, which basically says, if you're coming onto our territory to research, the following must be true, you must do these kinds of reviews, you must assign any copyright, you must pre-clear publication, you must share equally the basis of the proceeds. If you're doing that, that makes sense as a model code. On the other hand, a code that is designed, if you will, to be recognized as any particular tribe's understanding of their knowledge of their intellectual property, if as a model code, is dangerous. And I want to explain why it's dangerous. In part because many tribal councils and tribal people generally are traditional, They don't want to take a new step and adopt a new code unless somebody else has done it. And the first question you will get when you go to a tribal council with a new code is, well, what have other tribes done? And of course, therefore, if you have a model code, everybody will adopt it. There's only one small problem. The cultures differ tremendously. You don't want a model code for a tribe that basically shares its traditional knowledge communally and has no stewardship concept with one who has a clear line of stewardship of various kinds of knowledge. You want to adapt the code to the culture. So certain kinds of codes make sense as model codes. Other kinds of codes do not make sense as model codes, and you've got to be very sensitive to that difference.
I wish I had you people for longer. But what I'll do instead is I will hook you online and keep you on the email list. It has been my privilege and my joy to have you all here. I want to say thank you so much for participating, for coming, for generating all this information and knowledge, and for making this far more fun than it had any right to be. We have a small reception out in the rotunda for everybody, for those of you who want to stay. Again, thank you to all of you. A real pleasure. Have a good rest of the day.